Welcome to AVISION Institute and welcome to our new YouTube channel for Clat, AILET and other law entrance exams. So, if you are preparing for Clat or SLAT or AILET, then this channel is for you. You can refer to this channel for law exams. If you are preparing for any other law entrance exams, then this channel is for you. So, please subscribe to our channel and don't forget to hit the like button so that you get all the notifications related to our law topics. So, we will be discussing some law related topics in this channel, and our faculties will be discussing your pattern wise, your question paper wise topics, and it is going to be very helpful for you for any law entrance exam. So, as you can see on the board, today we will be discussing about Law of Torts. So, let me first give you a small introduction of Law of Tort. This Law of Tort, we all know about Law of Torts. If we are preparing for any law entrance exam, we must be aware of this subject. Why this subject is important? This subject is very important for any law entrance exam. It is important for any semester exams for law students. It is also very important for WBCS and UPSC preparation students who are preparing for WBCS and UPSC and who have law as their optional paper. This subject is also very important for them. So, let us see what is first. Let us take a intro of tort. Tort is derived from a Latin term tortum, which means to twist. So, what is tort? Tort is nothing straight. It is not a straight thing. It means tortum, which means to twist. So, tort is basically a Latin term. It has come from a Latin term tortum, which means to twist. Now, what are the essentials? What are the essentials? How can you say that law has been constituted or this is a tort? Tort has been constituted. So, what are the essentials of a tort? Number one essential is some wrongful act has been done. So, you will have to prove what are the essentials of Law of Tort. You will have to prove that there is some wrongful act which has been committed. There is some wrongful act which has been done, which has been committed. Any wrongful act, any wrongful action which is not right has been committed by a person, or we can say has been committed by the defendant. Now, who are very new to law, new to this subject, and who are thinking of that we will be taking, will be sitting for Clat or any other law entrance exams, and you are just giving your 10+2, your 12th standard, then let me go to the basics. Now, who is the defendant? Now, if you are a law student or you have prepared Law of Tort, then you must be aware of this term defendant, as it is a legal term. So, let me tell you what is the defendant. Now, any suit, any civil suit, when it is filed in the court, then who files the suit is called the plaintiff, is called the plaintiff. So, any civil suit, the person who files the suit, who is aggrieved or to whom the wrong has been done is the plaintiff, and against whom the suit has been filed is the defendant. So, the wrongdoer is called the defendant, or the accused person who has committed the wrong is called the defendant. So, now what is the next essential? That some wrongful act has been committed by the defendant against the plaintiff. Number 2 is violation of a legal right or legal damage. So, by that wrongful act of the defendant, plaintiff's legal right has been violated. Plaintiff's legal right has been infringed. So, there are two new legal terms, infringed violated. So, what do you mean by infringed? These two are similar terms, infringed and violated. Infringement is also, is also means to break, violation means also to break. So, what happened? Wrongful act has been committed and that wrongful act of the defendant happened legal right of the, it violated legal right of the plaintiff. So, what are the legal rights that are vested on us? What are the legal rights that we have? So, we all are citizens of India and we all have some legal rights that the Constitution has given to us. There are some fundamental rights. You all know that Constitution gives us, provides us some fundamental rights. And we as a citizens of India, we all have some fundamental rights. Now, do you give someone this permission to violate your fundamental right? No, we do not give anyone this permission to break our fundamental right, to violate our fundamental right. We do not give permission to anybody. So, when your legal right has been violated by the defendant or any other person, then tort has been committed. Tort has been committed. So, this is tort. When our fundamental right is violated by any person, then tort is committed. Next essential is, number 3 is remedy or right to claim compensation. So, what is the remedy? My fundamental right has been violated by a person. What should I do now? There must be some remedy. Law must provide us some remedy of this wrong. So, what is the remedy of tort? The remedy of tort is right to claim compensation. So, if I am the plaintiff and some wrongful act has been committed against me by the defendant, what should I do now? I have the remedy to claim compensation or to claim damages, that is, you can also say, what is the meaning of damages or compensation? It is a monetary relief. So, you will be getting monetary relief in terms of money. So, compensation, damages, monetary relief, these all are similar terms. So, what is the remedy left in my hands? The remedy left in my hands is the right to claim compensation from the defendant, who is the wrongdoer. Next is what? Next is unliquidated damages. So, what is unliquidated damages? The damages or the compensation or the monetary relief is unliquidated in nature. So, you will have to understand what is the difference between liquidated and unliquidated. So, liquidated damages are those damages which are fixed prior, in a prior manner or previously which was fixed in a fixed nature. But the damages which is not being fixed is unliquidated damages. So, what do you mean by fixed damages? Like let me give you some example. In a contract or in an agreement, when we make an agreement, just say any kind of agreement, okay. So, when there is an agreement, we sign an agreement between me and a person, we are signing an agreement. What happens there? There are certain clauses written in the agreement that if any of the parties violate the terms of the agreement, then he or she will have to pay this amount of compensation or damages. This amount of compensation or damages, the amount is fixed in that agreement, that if violation occurs, then this compensation you will have to pay. So, this is called liquidated damages, that means which has been fixed previously or in a prior agreement it has been fixed between the parties. Means it was fixed with the free consent of the parties. Again there is a new legal term, consent, and it should be free consent. So, free consent, sorry, it should be consent NT. Okay. So, free consent, this term we will be describing, we will be discussing in detail. This you are going to get in contract. In contract law, Indian contract law, you will be getting this term free consent. So, without a free consent of a party, no contract can be signed if the consent is not free. If the party does not consent, does not give permission with his own self, nobody can force him to sign a contract. That is illegal in nature. Okay. So, this is all about unliquidated damages. So, in case of a tort, the damages are not fixed from before, it is not previously fixed between the parties. So, this is called unliquidated damages. Number 5 is damages determined by a judge. So, as in tort, the damages are unliquidated. It has to be fixed by the judge, by a civil judge. When the plaintiff will go to the court, then the judge will fix the damages, or the judge will say how much the defendant has to pay compensation. The judge will declare that. Next, let us come to what is next. Next, you can see tort is a civil wrong, but every civil wrong is not a tort. So, we call tort as a civil wrong. You will find it in law books everywhere that tort is a civil wrong. It is written everywhere. So, we know the meaning of this, that tort is a civil wrong. But again you will have to know that not all the civil wrongs are tort. Tort is itself a civil wrong, but there are other civil wrongs which are not a tort, which are just civil wrongs. Okay. So, the other civil wrongs which are not a tort are these. You can say breach of contract, you can say breach of trust. So, what is a breach of contract? Breach of contract means, just suppose I have signed a contract, or some parties have signed a contract between themselves, among themselves. Now, what happens? If any party violates the terms of the contract or breaks the contract, breach means violation, breakage. So, if any party breaks the contract, then that is a breach of contract. There you can go to the civil court and you can file a case against that party that he has made a breach of contract. Or if there is in the contract, if such things are mentioned from previously, that if any party violates the contract or makes a breach of contract, then he will pay this much compensation. Then if it is agreed previously between the parties, then if the contract is broken, if the party makes a breach of contract, he will have to pay that much compensation as agreed upon previously. So, next is breach of trust. This is also a similar like contract. this is a contract between, this is a trust contract between trustee and the beneficiaries. Okay. Then in that case also, if a trustee breaks the contract, then the beneficiary can claim compensation. How much the trust property suffers loss. So how much compensation he will have to pay? The trustee. How much the trustee will have to pay? The trust property, you will have to see how much the trust property suffers damage. That amount the trustee will have to pay if he breaches the contract. Next, let us go to the next slide. So before going to the next slide, as you can see, it is the difference between a civil and a criminal wrong, which is again very essential for you to differentiate. To differentiate between a criminal wrong, a crime, and a civil wrong. Okay. So it is very essential for you to differentiate. Let me tell you in short what we can call a tort. A tort, we can say that we all have some duties as citizens of India. We all some duties has been vested upon us. So we all have some duties that we cannot defame anybody, Again, this is a new legal term. What is defame? Defame means to harm the reputation of an individual, that is called defamation, or to defame a person. This term you will find in tort when we will go into details about the terms that are in tort. So this is my duty that I cannot defame a person. I cannot commit nuisance. So if I am a responsible citizen, of India, I cannot commit a nuisance. I cannot commit a public nuisance. Just suppose I go to the middle of the road and I started fighting with somebody and I create a chaos and the public, and there was a traffic jam and the traffic was disrupted. So what did I do? Did I do the responsibility of a responsible citizen? No. I made a chaos and created a public nuisance, which caused harm, which caused damage to the public. So I cannot defame anybody, I cannot create a nuisance. So now we know these are responsibilities, or these are duties that are vested upon us as responsible citizens of India. Now if we break these duties, we do not fulfill it, then that results into a tort. So in short, we can say breach of these duties that are imposed by law, that are imposed upon us by our law, by the constitution, that results to a tort. Now let us see the difference. What is a civil wrong? Civil wrong is wrong against individual. It is a civil wrong. So a private wrong can also be said as a civil wrong. So basically tort is a private wrong. So the wrongs that are done against an individual, done to a person, an individual, it is a private wrong. It is not done to a public or a community or a society. So that results to a criminal wrong. When the wrong is done to a large amount of people, to a community, to some group of people, okay, to the state, then that results to a criminal wrong. When society is involved, but when the wrong is done to a single individual, then it results into a civil wrong or a tort or a private wrong. Now in criminal wrong, what we can see, wrongs against state, that is also called a public wrong. So why state involved? Why is state involved? So if I commit a criminal wrong, Just suppose I committed theft. I committed theft means I went to some building and I committed theft there. What will happen now? It is a criminal wrong. But why state will be involved? I committed theft to an individual's house. It was the house of an individual. So then how will state be involved? Why is state is involved? Because state sees, or the government sees, government involves itself in those criminal cases where it sees that it is a crime against the society. It is a crime against the society. So when government see that the crime is against society, it is harming the society, then the state interferes and that results into a criminal wrong. Okay. Next is injured party claims compensation in case of a civil wrong or a tort. So in a tort or in a civil wrong, the injured party means the party who faced the harm, or to whom the harm has been caused, or to whom the wrongful act has been done, against whom. He or she is the injured party and he has the right to claim compensation from the wrongdoer or from the defendant. Criminal wrong is injured party seeks for punishment of the wrongdoer. In criminal wrong, the injured party wants punishment of the wrongdoer, not any compensation, because it is a heinous act, because it is much more serious in nature. May it be a rape, may it be a murder, whatever it may be. So in this case, the injured party asks to the court that please give punishment to the wrongdoer. Next is what? Number 3 is, it is much less serious in nature. Yes, civil wrong is much less serious in nature, and this criminal wrong is much more serious in nature. Alright, next is, injured party himself has to file a suit against the defendant. So in case of a civil wrong or in case of a tort, state is not going to involve itself in your case. So it is not a big crime, it is just a civil wrong. So state is not going to come here. You will only have to file a case against the defendant. So injured party himself has to file a suit, a civil suit, against the defendant or the wrongdoer. Next is what? In case of a criminal wrong, proceedings are brought by the state against the wrongdoer. So in case of a criminal wrong, just suppose that a girl was raped, okay? A girl was raped and she is the injured party then. The wrong has been committed to her, but she has not to do anything. She has not to do it. She do not have to do anything. The state will come in favor of her and the state will continue the proceedings against the wrongdoer. The state will take the responsibility and the state will take the responsibility to punish the rapist. No responsibility lies to the injured party in case of a criminal wrong. All the responsibilities are borne by the state. Next, you can see the examples. Examples of civil wrong are trespass, negligence, nuisance. These are all examples of civil wrong. So trespass means forcefully entering into somebody's property or land or whatever. Negligence means if you are negligent, okay, if you are negligent in your behavior and your negligent cause harm to somebody else, that is called negligence. Nuisance, we have discussed what is nuisance. Number 5 is rape, murder and theft. These are all serious crimes in nature. Now, so as we have gone through the difference between a civil and a criminal wrong, I guess this concept is clear and you can differentiate now between a civil and a criminal wrong. One more thing is very essential in case of a tort which you should keep in mind. That is, mens rea. So this is a legal term, this is another legal term which is very important in case of a tort, that is mens rea. What is the meaning of mens rea? The meaning of mens rea is a guilty mind. So guilty mind is very essential in case of a tort. To prove a tort, a guilty mind, a person was having a guilty mind or not. If he was not having a guilty mind, if his mind was not guilty, he did not want to do that crime or do that harm to the injured person, then he is not guilty of a tort. So mens rea, that is guilty mind, is very important, very essential for a tort. Just suppose, just let me give you the last example, just suppose that I am unaware that beneath my land or beneath my ground where I am standing, or where my building or my house where it is situated, beneath the ground some electric wires are there. Okay, electric wires are there, and I am not aware of it. Now being unaware of this condition that there are electric wires, I started excavation and I caused harm to the electric wires. Now am I responsible for this act? Because I was unaware, nobody told me that there are electric wires, be careful of that. So nobody told me that, I was unaware of it. So I am responsible or not? No. In case of tort, in the eye of law, I am not responsible because I did not have a guilty mind. My motive was not an ill motive. My intention was not wrong. It was not an ill motive. So my mind was not guilty, so I am not guilty of a tort. So I guess the concepts of tort is very clear now. I can make clear the concept of tort. So this was all about tort. Thanks for watching, and please subscribe to our new channel of Clat, AILET and other law exams of AVISION Institute. Please see our other videos. Please register to our paid courses also. There you will find many other videos which are in details and which you will find descriptive topics. Thank you.